in this main meeting room at this point in time. We have concluded our executive session, and I would turn it over to Attorney General Davenport for next steps. Kyle, you're still on mute.
Thank you. Sorry about that, everybody. Commissioners, we just have one procedural matter to take care of. Commissioners will returning from executive session. During executive session, the commission received legal advice, as indicated on the agenda, on Senate Bill 181's amendments to the Oil and Gas Conservation Act. We did not actually get to Colorado open meetings law in this executive session. No decisions were made and no votes were taken. Mr. Chair, I invite you to encourage a motion to exit executive session.
I so encourage a motion.
I move to exit executive session, Mr. Chair.
And do we have a second?
Second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Anybody opposed? Mr. Davenport, I think we're successfully out of executive session. Do you have further on this at this point?
Nothing further. Thank you, Mr. Chair.
Okay, great. All right, so the next part of our agenda was to discuss the 200 to 600 mission change rulemaking hearing schedule. Commissioners, we put this on the agenda because at this point we have set aside 3 weeks, with the exception of Labor Day, August 24th through September 11th, I believe, for the 200 to 600 series rules. And we now have had an opportunity, I know we're all doing a lot of homework, we're reading pre-hearing statements, so we're starting to get some sense of, what the staff proposal has generated in terms of stakeholder feedback. And we will be getting more of that on July 31st, at which time responses to pre-hearing statements will be forthcoming. And then I think the next deadline, and Ms. Larson can help me, it's sometime in mid-August, or maybe August 14th or thereabouts, is written testimony. So all of this is informative to us in terms of the undertaking of the 200, 300, 400, 500, and 600 rules. And I wanted to generate a little bit of discussion about how we might think about using that block of 3 weeks, except for Labor Day, in terms of thinking about how to how do we go about taking up rules. And this is just, in my mind, this is just initiating this discussion, and I'm not thinking that we need to formally adopt any sort of specific in terms of how we're going to go about this. But I just wanted to start getting you thinking about, the fact that, that's 3 weeks, but that's an incredibly short period of time to undertake a lot of consideration of rules. And so just to get us started, I put together, and I'm going to try to share my screen. Let's see if I can get this done. This will stop other screen sharing. Do you want to continue? Yes. Here we go. Okay, so this is from my screen, and this is just to sort of get us talking about how to best use the 3 weeks that we set aside for rulemaking starting August 24th. In my mind, I think it might make sense, instead of taking this up sequentially, so starting with 200 and then going to 300, 400, 500, but to start with 300 series. That's kind of the main series in terms of permitting and what staff has proposed and what we're hearing from stakeholders about that 300 series. And so this just starts to give you, and this is just, to get us talking, but this starts to give you some sense of how that time will quickly be filled up. So if you look at this, and I've talked with Mimi and Julie about this, and but if you look at this, if we start on Monday the 24th, give staff a chance to introduce the 300 series, and then we would set it, the idea there is from 10:30 until 12:30, and then a break, and then 1 to 5, and then doing some public comment in the evening. But this would allow for public comment on all of the series. And it would basically, it's an entire day, including into the evening, of public comment. We would anticipate informing members of the public that if they want to comment, then they would sign up for that comment, and then currently they would give a comment under Rule 510. And this day would be set aside for those folks that are interested in providing perspective to us and who are not actual parties to the rulemaking. So the parties to the rulemaking have a different time in which they would present. But this sets aside a day for public comment, essentially, and into the evening. I know that, there has been consideration that we should ensure that we give folks a time to talk during the day as well as in the evening, and so that's what this tries to do. Then, and the rest of this is sort of falls in a similar pattern. It is, we start with staff presentation, we then move into party presentation, and this starts with the 300 series. And so we've got a day and a half of staff and mostly party presentations. And then we've set aside approximately a day on the 26th and the 27th for commissioner discussion, commissioner deliberation. And then if you look at this, this gives a little more time for the 300 series than the rest of the series, but it's all in a similar format. So toward the end of that week, we would move to 500 series, which is the permitting series, and I think it flows nicely after our consideration of 300, which is, so 500 is kind of our rules and practice, 300 is our permitting. So you can see there we've got staff presentation for a hour and a half with commissioner questions to staff. Then we start party presentation on the end of the 27th and into the 28th, and then we close out that first week with a break starting back up on August 31st. I'm trying to scroll without creating too much of a problem here. So then we start up commissioner discussion on 500 the morning of Monday after we've had a good weekend to take a break. And then we move into staff presentation on 400, party presentation on 400. 400 is the operations and reporting procedures. And then we do the same with the 600, which is the safety and facility operations procedures. We have put in a hold on September 4th, the Friday afternoon. We're probably going to be exhausted by that point in time. And then we do take the Labor Day off. And then we move into 200 series on the 8th and 9th. And then we have 2 days of hold on the 10th and 11th in case this entire schedule, has bogged down. And so we've got some additional time there. I'll finish my remarks and then we can take comment amongst commissioners about all this. A couple of things that I would say is you will note that in order to get all this done within the 3-week time frame, the party presentations, and we have upwards of 45 or 50 pre-hearing statements from parties in each of the series, we're not going to be able to have time for lengthy party presentations. And so what we have asked the parties to do is brief their positions in both their pre-hearing statement, the response to the pre-hearing statement, as well as the written testimony. So they'll be providing written testimony. And then we found that we can be successful in rulemaking when we allow commissioners to be fully prepped with reading all of that, including the written testimony. And then the large part of party presentation allows commissioners the chance to ask questions of the parties during that time. So that is kind of an overview of one potential method of going through this. I would throw it out for commissioner discussion. I think first we should think through do folks like the numeric order of doing 3, 5, and then 4, 6, and then 2? Do you think that we ought to do it in another fashion? And then we also should discuss, how staff and I have sort of broken out this proposed agenda. So,
Mr. Chair, I've got a question first.
absolutely.
So when we are approving these rules, or more voting on these rules, on this rulemaking, are we voting on them on a series basis, or are we voting on them all as a whole, kind of a package deal at the end of all discussion and deliberation?
Yeah, that's a great question, Commissioner Gonzalez, and that's a question we need to answer amongst ourselves in terms of how's the best method for going through these. And that question also sort of begs the other question, which is, 2.5, 3 weeks after we're done with 2 through 6, we're going to take up 8, 9, and 12. I think I try to answer that question by saying I would really like on September 9th or 10th or 11th or whatever it is, if we feel comfortable with it, we hold a vote on the 2 through 6 series so that we can establish some finality to that, but with the idea that we may need to go back and revisit some of the areas of 2, 3, 6 as we take up 8, 9, and 12. That's just, my thought. I get a little concerned if we don't vote on 2 through 6 at the end of that 3 weeks and we leave it open, then it leaves it open for everybody to sort of wonder about, do we need to revisit some things that we've already gone through? So, the alternative is we take up on, say, the 26th, a vote on 300, but I'm not as comfortable with that. And again, this is just my answer to this. I'm curious as to other commissioners' answers. There are things in 5 that implicate 3. And there are things in 4 and 6 that I think need to be thought about before we wrap up 3 in particular. So I would suggest that we, at the end of the commissioner discussion on 300 at, say, the August 26th, we get kind of a conceptual thumbs up. We think this is where we've got majority consensus on this. Let's move to the 500, and then let's do the same thing. And then at the end of the 3rd week, we could sort of wrap everything up in a final vote, knowing that there may be things we need to revisit in 8, 9, and 12. So I'll stop talking and allow for other commissioners to answer that question or ask other questions.
Chair,
Yes.
do we have to vote, or can we close the record, understanding that we might have to go back and change something based on decisions that we make in the later set of rules? I'm just curious.
Yeah, that Commissioner McGowan, I think that's an excellent thought. Is that if we at a minimum, and I think a lot of it's going to depend upon where we feel we are at as a commission as we go through these 3 weeks. But at a minimum, I think we would want to ensure that we're closing the record on 2 through 6 so that we, are not going back and revisiting additional public input, stakeholder input, party status input, et cetera, knowing that we may need to revisit some parts of 2 through 6 as we think about 8, 9, and 12. And I also would encourage Hearings Officer Larson or Director Murphy to, jump into this discussion as well. You guys have infinite wisdom in rulemaking. You've been through it a lot.
For what it's worth, I think, Jeff, you've charted a good course in terms of trying to get us through. It will require all of our discipline to stay on schedule, but I also think it's accomplishable.
Commissioner Mesner, I see you've unmuted yourself. Did you have something?
Yeah, I was just going to support the idea of being able to vote on the entire 2 through 6 series at the end of the time that we take to deliberate on all of them, understanding that we may need to go back and make adjustments as we move through the different series. So I think that makes sense. And just anecdotally, as I look at the schedule as a timeline, I do think this is going to be, a challenging 3 weeks that we're going to be working on here. So I think making sure that there's time in there for the commissioners to be able to step away and have some lunch or, think about things a little bit so that we're not filling it up so full that we're going to get ourselves overwhelmed in the 3rd week. So
I would also piggyback on that, Mr. Chair, and potentially offer a suggestion that maybe we carve out some time somewhere in the middle of these weeks to have potential, or leave it open there for an executive session to consult with our AG on any matters that come up or any questions we have along the way.
I think that's an excellent thought as well. Others? Commissioner Nanjaba, did you, I can't see you. You're not on my first page. Did you have anything? No? Okay. Our
Mr.
folks,
Chair,
go
sorry.
ahead. Mhm.
I'm just curious if it's normal to just have public comment at the beginning and not have public comment again for the entire time, knowing that we're meeting for 3 weeks and discussing things for 3 weeks. I don't know what the normal procedure is for the commission, so I'm just throwing that out there.
Yeah, well, we're outside of normal, so we'll start there. And I think that's a valid thought. And the other thought that comes to mind is that that's just setting aside one day, and if there are members of the public that aren't available that day, then they are reduced to being able to only submit something in writing. So, I think I would probably look to Director Murphy and Hearings Officer Larson to maybe let's think about both that idea of creating a different public comment day, maybe during one of the evenings, as well as thinking about Commissioner Gonzalez's idea of holding some blocks open for, I don't know if it's executive session or if it's other time for us to talk amongst ourselves or whatever it may be, or gives us a chance to take a break and go for a run or whatever it may be. Ms. Murphy, it looks like you were about to speak.
Thank you, Chair. The one thing I would offer Commissioner McGowan is that one of the pieces that's been important to me broadly as I've been structuring public comment time before commission hearings is to make sure that the public or the public commenters have the chance to talk in advance of the commission decision that's being made. And so I think it's on the one hand, the conversation may evolve and people's comments may change, but I would hate for somebody to have a comment about the 300 series of the permitting process, but they don't come into the conversation until after a lion's share of the commission discussions have occurred. And so it's a difficult balance. I think that the chair has articulated a good course. And then the other piece is that making sure we provide kind of certainty to our commenters about how and where to engage meaningfully. So I think, as I said, I think the chair has articulated a great course where we can adapt and evolve as asks for it or the need for it changes. But I do think that setting up that first day to really hear from folks who want to engage on any issue makes a lot of sense, so that can inform all of the rest of the conversations that you hear and participate in, for what just my observations.
Mr. Chair?
Yes, Ms. McGowan.
Thanks, Julie, Director. I support public comment at the beginning. I'm just wondering if we're going to want additional public comment toward the end after we've had a lot of discussion and people can see potentially where we're heading and might have thoughts about that. And maybe we won't need to. Maybe it'll just be pretty clear based on public comment at the beginning. I just didn't know what people thought about that.
Mr. Chair, do you mind?
Please, Attorney General Davenport.
Thank you. I just very briefly, Commissioner, I want to make sure that you're clear on what closing the record means exactly. Closing the record is an important procedural step. What it means is that you have received all of the substantive information from the parties that you believe you need to make your decision. And that includes substantive input from the director and staff, even though they're not a party to this rulemaking. The director and staff, if you want to make a change to a rule after you've closed the record, they can help you do that. And they can point out things like, now we have to go back and change this rule as well. But closing the record does mean that you feel you have received all of the substantive input you need from the stakeholders, the public, the director, and staff. And so it is certainly an option to, as the chair has already suggested, have a kind of soft approval as you get through each rule series. But it would be important for you to think carefully about when you close the record. You don't need to close the record on the 300 series on August 27th. You can keep that record open in the event that through the rest of the 4 through 600, 500, 200, you think you need to go back and get substantive input from somebody on the 300 series again. But closing the record does mean that you are done receiving substantive input from the public, stakeholders, and the staff on a particular rule series or the entire 2 through 600. And the only other thing I'll point out is I do not recommend that you take a formal vote on any rule series until you are absolutely certain that you are not going to make any more changes to that rule series.
Mr. Chair.
Yes, Commissioner McGowan.
So I guess maybe I'm not understanding your original recommendation, which I thought was to vote after we're done with the series and then move on to the October hearing. Is that not what you were recommending?
I think there's pros and cons to either method. And again, we're sort of outside of the normal rulemaking. I have a hesitancy that I see some benefit to closing the record at the end of the 3 weeks for the 2 through 6. I think that's a positive and a worthy thing to do, so that we are sending a message that we've received all that we need to receive on those series. I also see a benefit to holding a vote on those series at that time so that we can reach finality on those series. But I also see some, and I can argue both sides of this. I also can see that if we've got a sort of tentative thumbs up on those series, we're close the record so that we've informed the world, we're not taking additional information, but we leave it open so that we can debate 8, 9, and 12, and then at the end of that, have a vote on everything. I sort of see kind of some pros and cons on that, and maybe that's the better method, is that we get closure on the public's and the party stakeholders' input into 2 through 6. We do a conceptual thumbs up on what we think is the majority rule, but we hold off on the actual vote so that that rulemaking is still open. And then we conclude both rulemakings at the same time after we've gone through 8, 9, and 12. And I would relish hearing from Attorney General Davenport and or other commissioners about, the pros and cons of that.
Mr. Chair.
Yes, Attorney General Davenport.
Thank you. So one thing I do want to mention is, and the commission has certainly done this in the past, for example, at the conclusion of the 300 series, as is scheduled tentatively now, the morning of August 27th, you could have a sort of provisional tentative check-in / thumbs up / vote that is clearly not your final vote on things, but is the commissioners all saying, I would vote to approve the 300 series when we get to that point as they exist now, recognizing that that is not your formal final approval of them. And I do think that makes some sense. It is something the commission has done in the past, have a check-in to make sure that there is no commissioner who is saying I won't vote to approve these rules as they exist in this form. When we get to that final formal vote, whenever that is, a conceptual check-in has been done in the past. It's something you can do just to make sure that there's no commissioner that still has such significant disagreement that they just couldn't vote for those rules when you actually get to the formal vote.
And then Attorney General Davenport, what are your thoughts about closing public record, but not closing down the hearing on 2 through 6, and then moving to 8, 9, and 12, doing a similar thing, and then at the conclusion of 8, 9, and 12, we hold a vote that is for all of the series, a formal vote?
I think that's a good option. Two things I'll point out there. The commission itself can discuss these rules as much and as long as it wants after it closes the record. It just is done receiving substantive input from the public, the parties, and the staff at that point. It's not receiving any new information at that point. The other thing I'll mention is the rules do provide that the commission, upon majority vote, may reopen the record. So you can go back on closing the record. I think has the potential, reopening the record has the potential to create some procedurally messy issues, because it does reopen the record for all the parties to provide additional information, et cetera, to you. But reopening the record is an option after you've closed it.
Thank you, Attorney General Davenport. Commissioners, other thoughts, questions?
Mr. Chair,
Yes.
I like the idea of voting on the various issues after we get through all of the input, and also keeping the record open. I think that makes sense to allow us to look at those areas of intersection among the different series, and to think through the different issues and see if we do need additional information, especially from staff in some instances. I also really appreciate the suggestion from Commissioner Gonzalez of some space for executive session in between, just to make sure that we're fully understanding kind of the extent of our interpretation of the law, et cetera. I think that would be really helpful, because it is a lot in a short period of time.
Thank you for that. Other thoughts from commissioners?
Mr. Chair.
Yes, Commissioner Gonzalez.
I appreciate the all the suggestions made by the various commissioners for how we go about doing this. One thing that I think is important that we keep in mind is as Commissioner Nanjapa just mentioned, is the interaction, the intersection between the various series. I think it's really important that we understand that when we're making determinations on one series, that has implications on other series, and we need to understand the complete picture of what that looks like. While I appreciate the suggestion and I am withholding any kind of vote on the matter for closing the record after we're done with the 2 to 600 series, I think that's maybe a decision we should hold off on until we've been through that process to determine whether or not we are ready to close that record at that time. It may be the case that we may want to hear from other parties or other members of the public at that time, additional questions, what have you. Not sure if that's appropriate, not sure what the procedure looks like for that, but I would hold off on making that determination, or I would suggest we hold off on making that determination until we've completed our deliberations on the various series.
Thank
Mr.
you,
Chair?
Commissioner. Yes, Commissioner McGowan.
Sorry, my suggestion was to close the record because I thought the recommendation was to vote, which felt more final to me than just closing the record and knowing that we could reopen the record. So that's the only reason I suggested it. So if instead what we're saying is we take kind of a soft thumbs up, thumbs down, we move on to the next series, knowing that we're going to come back if we need to amend anything and then take a final vote, I'm fine with that as well.
I see a thumbs up from Commissioner Nanjaba as well. I think Commissioner Gonzalez, I appreciate those thoughts, and ultimately these decisions will be made in real time. We're not, obviously, I started this by saying we're not making any decisions today. I just wanted to get us started thinking, because how we go about holding the hearings will influence the homework that we're going to be doing between now and then as well. I wanted us to start thinking about, sequentially, do you think the moving 3, 5, 4, 6, 2 makes some sense? I'm not seeing any sort of nodding against that part. Yep, thumbs up. Okay. I guess what let's do is we just want to, I wanted to start this discussion. I think this has been helpful. I think I would turn to Director Murphy and Hearing Officer Larson to work with me on incorporating some of these suggestions into this schedule that will continue to flesh out. And then what I would suggest to commissioners is let's revisit this after we've had a chance to review the responses to pre-hearing statements that are due in July 31st, I believe. So maybe the first or second week of August, we can have a sort of more final discussion that this is the sequence we think makes sense, because I think we'll fully understand what the positions of the parties are and where there's consensus and where there's not. Any other thoughts from commissioners? I want to give Director Murphy and Hearings Officer Larson a chance to chime in now that we've heard from some of the commissioners on some of these topics. Or not. They're both smiling, so that's good. All right. Very good. I think that, I mean, again, we just wanted to have an initial discussion. I think that this has been very helpful. We will update the schedule. And I think that, I just inform you, and I know that you're doing this, but I inform the rest of the parties that are listening in. Commissioners are spending inordinate amounts of time reviewing pre-hearing statements and reviewing the proposed rules. I guess I would just like to state for the record that the concept that we are professional, full-time paid commissioners is really making some sense at this point, because this is a heavy undertaking that we are working on. And I think that, applaud the legislature for realizing that this pivot actually might, is an important one for us to get implementation of 181 done right. So with that, anybody have any closing remarks? Raise your hand. I'm seeing none. I guess I would seek a motion to adjourn.
I'll make a motion to adjourn.
Do we have a second?
Second.
Okay, motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Great, guys, we're done. Thank you very much. Thank you, Colorado. We'll be back in touch next Tuesday.
Thank you, Mr. Chair.